Hi, everybody. I wanted to take a few minutes to talk about basic memorandum writing in legal research. So, one of the things that you'll be doing whenever you're conducting legal research is writing, the work product, right? They give you a research assignment and they say, write a memo. Okay. The style of the memo writing is just to inform. Okay. You're telling the reader what the status of the law is. You're not arguing one position or another. You're talking about the strengths and weaknesses. Um, yeah. So we're given a legal problem. We're writing our analysis based upon the facts of the situation given to us and applied to the law. Okay. We're just informing. We're not persuading here. So don't get all argumentative in it. We use these memos, they're internal. So you're writing it to someone else in your office. Say, what should we do next in a case? What are things going on at trial? Maybe, we have a motion coming up. We have evidence we want included or excluded. What are our arguments? Okay, we want to know what arguments are from the other side too. So we don't want to just always find what's good for us. We want to know what to expect from the other side, so we are not blindsided. Um, it's These kinds of assignments are given to the lower tier or the newer experienced people in the firm, a newer attorney, a paralegal, an intern, and you can have a simple memorandum or a complex memorandum. In the fundamentals class, you did a complex memorandum. Here in this class, I'll only ask for simple memorandums because I really just want you to be working on your research. So we have our heading, then you have your facts, issues, rules, analysis, conclusion. That's your basic format. Okay, your heading, right? Memorandum from to whoever it's to, from you, your date. When you're in a firm, you're going to have a file number so that the person knows where to file it, where to go, where it goes, the name of the case or the matter, and then regarding what is it about. Okay, so this is only really if you're at a firm, and having the file number is helpful for organizational purposes. Okay, so your facts. Your facts are the facts of the issue for the case, for the matter that you are seeking an answer to. Okay, your facts are not the summary of the facts of the research of the cases that you've researched. Okay, so attorney comes into your office. Hey, we have a client. This is the client's problem. This is the client's situation. Those are the facts. Uh, don't go all in depth on the facts. Only, include what the reader needs to understand the factual situation. Um, don't include irrelevant facts or, you know, things that just make it lengthy. But after you write your memo, go back. After the facts that you're using to analyze in your memo, the body of it, make sure that you've mentioned them in the original facts section. Okay, so your issues. The issues are legal issues. Okay, they're not, did he speed, right? That's a fact that we have to determine through evidence. A legal issue are questions that need to be answered by the court. Okay, and those are the legal issues we're going to be then discussing in the body of a memo. When you write your issue, write it as a question. Is life imprisonment without parole for a minor cruel and unusual punishment under the US Constitution? Okay, don't say whether the blah, 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 blah. Whether, when you're just putting whether in front of it, doesn't make it a question, it just makes it a sentence fragment. So don't use whether. Okay, if you have a complex set of facts and you have multiple issues, you might use multiple issues in your memorandum. If the issue itself is complex, you might separate it into sub issues or mini issues. Okay, break your issues into whatever the smallest parts so that they can be addressed without making it confusing for the reader. Okay, so the rules are the laws. Okay, so the laws might be the Constitution of the United States holds that there shall be no cruel and unusual punishment. And then you might have just a general summary of the law of one or two cases that you're going to be discussing later in the memo. Okay, don't cut and paste, major paragraphs or an entire statute. Like, that's not helpful, right? The attorney or the person reading the memo could have done that themselves. Okay, you're kind of summarizing it, paraphrasing it. And if you are citing to a case or a statute, then tell what it means. Don't just say boom, 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 because that's the purpose of the memo, to explain how that statute has been interpreted. If there are specific rules, set forth the elements of the rules. What steps need to be followed for that rule to apply. Okay, we don't want any secondary sources here. We only want primary laws, cases, statutes, regulations, constitutions. And make sure you're in the correct jurisdiction. Don't give me stuff that is irrelevant to my jurisdiction. Okay, so in your analysis, you're going through your issues one by one. You're going to make a separate heading for each issue so that it's well organized. You break your rules of law into elements, and then you determine if the elements are satisfied. So for this law to apply, these 4 things need to be present. And in our facts, only 3 of them are present. Go through them one by one. And that's how that, whether this case applies and what the law is. Now, if there's law that works against your client, bad stuff, include that as well. We call that counter analysis. Okay, so we had your facts, issues, rule, analysis, and now your conclusion. Okay, you might have answered your issue questions in the analysis, but put it right there, because a person reading a memo might skip to the end, right? There are the people who go to the end of the Agatha Christie novel and find out who the murderer is. So just to get to the point quickly. So summarize your answers to all of the issues at the end. You can give a personal opinion here as to which side has the strongest argument, or which side will prevail, and why you've reached those conclusions, or maybe our next steps. What should we do next? The other thing that's super duper important is any law that is mentioned needs to be cited. You can't just put forth the law clearly states, cite without a cite. So you need citations to support every statement, every legal statement that you're making. And then those citations should appear in the body of the document, not as a footnote or an endnote. And make sure that your case and statutory cites are in Blue Book form. So that's my spiel on memos. If you have questions, feel free to reach out.